Ready? Start. Challenge in this criminal appeal is to the final judgment and order dated 28/4/2017 passed by the High Court of Judicature at Allahabad, whereby the appellant's petition under Section 482 of the Criminal Procedure Code 1973 seeking quashment of criminal case number 7489 of 2002 pending on the file of Chief Judicial Magistrate Ghaziabad for offences under Section 420 of the Indian Penal Code 1860 has been dismissed. Stop para. Brief facts necessary for disposal of the criminal appeal are that the appellant S.C. Garg was the managing director of the company Ruchi Papers Limited, which was engaged in manufacturing craft papers. The company had business dealings with ID Packaging, a partnership concern of respondent number 2, Aryan Tyagi. Stop. In conduct of business between two entities, the parties used to maintain a running account and Tyagi used to issue checks from time to time in favor of ID Packaging. Stop. Between 22/12/1997 to 30/1/1998, Tyagi issued 11 checks which were initially dishonored due to insufficiency of funds in the account. Stop. To maintain business relations, both the parties agreed to present the 11 checks again at a later stage upon instructions from Tyagi. Stop. In relation to the liabilities other than the amount involved in the 11 checks, Tyagi made payment by issuing 3 demand drafts in the name of the appellant's company. Stop. On 8/6/1998, 11 checks were again presented for encashment, upon which only 4 checks were cleared, leaving the remaining 7 checks to be dishonored again. Stop. The appellant's company filed a complaint under Section 138 of the Negotiable Instruments Act 1881 against ID Packaging and Tyagi in relation to the 7 dishonored checks. Stop. On 25/10/2002, the learned magistrate convicted Tyagi for offence under Section 138 of the NI Act. Stop. His defence, that there is no enforceable debt as the amount involved in 7 checks has already been paid through the demand drafts, was rejected with a specific finding that the demand drafts pertaining to other liabilities of Tyagi to the company and were not towards liquidating the liability arising under the checks in question. Stop. Tyagi was sentenced to imprisonment till rising of court and pay fine of rupees 3,20,385. Stop. The appeal preferred by Tyagi challenging his conviction under Section 138 of the NI Act was dismissed by the learned additional sessions judge on 17/3/2005 by affirming the finding, conviction and sentence awarded to him. Stop. When 138 NI Act proceedings were pending between the parties, Tyagi moved an application under Section 156(3) CRPC seeking registration of an FIR against Garg and company inter alia, alleging that despite payment of amount involved in 7 dishonored checks, by way of separate demand drafts, Garg again presented 11 checks and fraudulently realized the amount from 4 out of 11 checks, thereby cheating Tyagi. Stop. FIR number 549 of 1998 came to be registered against Garg based upon the above allegations. Stop. However, the company was not made an accused in this FIR. Stop. The charge sheet filed against Garg on account of being the managing director of the company and Mukesh Kumar Baghel, director of Messrs. M.V. Agency in again, without joining the company stop. The learned magistrate took cognizance of the alleged offence and summoned the accused persons, including the appellant. YD order dated 19/6/2003. Stop. Garg preferred a petition under Section 482 CRPC for quashing of the charge sheet and the summoning order dated 19/6/2002, which has been dismissed by the High Court under the impugned judgment and order. Stop para. Mr. Siddharth Agrawal, learned senior counsel appearing for the appellant, would vehemently argue that the appellant cannot be prosecuted for an offence allegedly committed by the company without arraying it as an accused, that too without making any specific allegation against Garg. Stop. He would submit that the impugned prosecution has been instituted as a counterblast to the concluded proceedings under Section 130